各位同事
Members, good afternoon. It's 2:30 sharp. We have a quorum. I call the meeting to order. This is the 13th meeting of the Bills Committee on Stamp Duty Amendment Bill 2013. The first item on the agenda is meeting with the administration as a continuation. Before the administration joins us, I will declare as usual I own properties and my occupation is an accountant. The company I work for provides various tax advice, but I do not provide such service myself. Mr. James Tian, I won't be as mouthful as you are. I am engaged in real estate. Kenneth Leung, I declare that I provide taxation services and I own properties. Mr. Wang Ting Kwong, I declare as I did before. Secretariat, you really have to deal with this issue. There was no meeting to discuss about this yet.
When
the administration is ready. Last time, as you may recall, we stopped at CB bracket 11219/13 to 14 bracket 02. The administration was giving us replies in response to issues raised on the 14th and the 28th of March, and we had some discussions. My understanding is that the administration needs a little bit more time to give us a final response. Let's start from C. Mr. Sheck, you have to declare. I declare as I did before. Sorry, I wasn't here yet. Where are we? Is CB bracket 11219/13 to 14 bracket 02. Thank you. DS. In the last meeting, we had a thorough discussion about matters related to car parking space and instruments with more than one properties. We've also received some follow-up questions. We are liaising with relevant departments, including the Planning Department, the Lands Department, and the Office of Stamp Duty. We are looking at the issues as a whole. So we will conduct analysis on all these issues, and afterwards we will reflect to the Bills Committee. In relation to C and D, they both involve replacement properties. The exemptions related to replacement property is in relation to the SSD and the BSD. The arrangements are similar. We have taken reference from those exemption arrangements when working out this one. In relation to 2012 bill about the BSD, buyer's stamp duty, well, other than matters related to urban renewal, there are also other transactions of the nature of acquisition for redevelopment in this one, and so we will introduce corresponding amendments. In relation to 29AL replacement properties, if the original property is affected by acquisition, and the owner have to sell not of its own volition, the new replacement property will have to be later than the time when the original property is owned. That will be specified. It will also be stipulated that it will be a replacement. That is, one property replacing the other. And this statement is very clear in the bill. And in relation to the principle of a replacement property, it's that if the original property, if it's a residential property, the replacement will be one as well. If it's a non-residential property, then the replacement property should be a non-residential property. When we're discussing 29A(L), we mentioned this principle. The idea is the same as the BSD. Members asked questions about individual cases. Say the original property is a mixed property. That is commercial, residential. We were asked about the exemption arrangements. If it is a composite property, according to the definition, according to the relevant instrument, if it is wholly or partly not for residential purpose, is a non-residential purpose, a non-residential property. If it states in the instrument that it is for residential and commercial use, then it is a residential property under the bill. In other words, at the acquisition of a replacement property, the person can buy a residential property or a residential commercial property. We would like to make it clear. Member also asked about a residential property and a non-residential property, say car parking space in the same instrument. Under our existing framework and the principle of stamp duty, when we look at whether a parking space is a residential property, we look at whether the two properties are in the same title deed. If it is in the same title deed and cannot be separately sold, it will be deemed as one residential property. This will be the definition when we apply the replacement arrangement. If it can be separated and sold, then they will be treated as two different properties, one residential, the other non-residential. And under the exemption arrangement of replacement property, the person can buy one residential property and one non-residential property. This is built on the basis of the framework and also similar exemption arrangements. Any questions on replacement properties? I'd like to ask. Previously, I asked the administration for some figures. You say that you have not received any cases that use the reason for acquisition of replacement property to ask for exemption. That's right. So basically, if it's a residential property, then the replacement property will be residential property, but there will be no restriction on the size and value. Yes. A member mentioned, and I'd like to supplement, that when it comes to someone purchasing a replacement property, we do not impose restrictions on size and value of the replacement property. Perhaps the self-occupied original property is at this level, and a replacement property is to be purchased. Under the existing exemption arrangement, a bigger or more expensive property may be purchased. We have considered the SSD and the BSD. The policy intent is that the replacement property is acquired not of the person's own volition, and the original property is acquired for redevelopment. We think that it's not appropriate to impose more stringent restrictions, and if we are to impose additional restrictions, it will be difficult for us to set at an appropriate level, say on size and on value. We don't want to cause additional nuisance. That's why we will follow the approach under the BSD. Well, definition of residential and non-residential, you refer to the title deed. If it says that it is not for residential, then it's non-residential. If it's a residential, you can only buy residential property. If it is a composite property, then the person can choose either to buy residential or non-residential. Well, the principle is that if the permitted use is residential or commercial, such property is treated as a residential property. When buying a replacement property, then you can buy a residential property as a replacement. The definition of residential is that it is for residential purpose or part of it can be used for residential purpose. For a residential commercial property, part of it can be used for residential, so it's treated as residential. So if for a residential commercial, part of it is for residential, is treated as a residential and the person can buy residential. Yes. Let's move on to the next part. D. Perhaps you can explain to us about D and E. D is on the number of cases. Number of transactions. Well, so far there is no such transaction. E. There's been recent cases when the IRD requires applicants to produce documentary proof. We would like to say that under the BSD bill, we asked eligible applicants eligible for exemptions, including Hong Kong PR, and they are acting on their own behalf. They are required to make a statutory declaration.
And the requirement of the statutory declaration, the template of such declaration has been handed over to the Law Society, and then the lawyers can ask their clients to fill out the declaration. And the aim is that the relevant HKPR may hold an identity card, and he should also claim that he's acting on his or her own behalf. So that declaration form is really for him to state that he is acting on his or her own behalf. So a member suggested that when such declaration is submitted, whether certain documents have to be furnished also. Say, in the case of close relatives, what kind of the IRD would consider as proof of such relations. Now, the close relationship is not a new concept. In terms of the SSD and also the BSD and also AVD regulations, we have exemptions for close relatives. So if we are to examine whether the applicants are close relatives, we would accept certain documentation, including marriage certificates, birth of certificates, and so on. So, but then if under exceptional circumstances, when, say, the applicants are too old, or when they got married, there was no marriage certificate, then the IRD will make discretion to accept other documents as proof. So that's the established practice, and this is acceptable. And that's also comprehensible to members of the public. So we do have some FAQs with the IRD to facilitate the public's understanding. So we're just following what's been practiced in the past, and we're not setting up new requirements here. Any questions from members? I have a question. Say, for the Stamp Duty Bill 2012 passed, or HKPR have to make an application and they do it by the way of a statutory declaration and they would do it through the lawyer. Is that correct? They can use a template. Is that correct? Now, as for the close relatives, they have to furnish extra documents. Is that right? Yes. Mr. Paul Chair. Madam Chair, I understand that in the community, in radio programs, we've heard complaints from people. All right. You originally announced that the Stamp Duty 2012 bill was enacted, and there were changes in the requirements during the scrutiny period. And then we knew about this requirement on the statutory declarations later on. And then people are affected, and they didn't have enough time to do the declarations, and they did it as a measure of rectification, and then they are charged extra fees because of that. So have you received such complaints? Is there any way that you can streamline or make exemptions, allowance for these people so that they don't have to pay extra? Madam Chair, myself and IRD colleagues, we have noticed that in the latest stage of the Stamp Duty Amendment Bill 2012, there are certain requirements of underage HKPR who ask the guardians or trustee to do the transactions on their behalf. And because of this, there may be abuse, so certain exemptions have been abolished. Now, after that amendment has been made, some law firms, for safety's sake, ask their clients to fill out a declaration saying that they are acting on their own behalf and they are not acting as trustees. So for myself and RD colleagues, we have received certain inquiries and we've heard views in that regard. In the legal sector, the lawyers are doing it out of the goodwill to protect their clients. And I know that the IRD has also received certain inquiries in that area. So perhaps I'll defer to the IRD colleagues to supplement on this point. Thank you, Madam Chair. We have received inquiries, and that is now when they first purchased the flats, they didn't do the statutory declaration, and now they have to do it. But they don't have to do it at the legal or law firm. They can do it on their own. And actually, in the FAQ on our website, we explained that they can do it at the district office or under the witness of a justice of peace, or do it at the IRD office. And in certain cases, even if the bill was not passed, some law firms have requested the clients to do the declaration based on the template that we sent out to the Bar Association earlier. If they have already done so, then that's good enough, because that was the same declaration form that we have issued most recently, and we are accepting that declaration, and they don't have to do it again. So do you mean that the members of the public can do the declaration through other channels, and they have the choice and not to do it in a law firm, and they don't have to pay extra? Do you have a template declaration form? Can people just go to your office and then use that declaration form to ask a justice of peace to be the witness? Yes, on our website we have a specially designed declaration form for this ordinance. So that's a template here. Now, apart from the website, are there any other channels? Do you provide it at the counter of the IRD office? Because people don't want to pay extra for doing the declaration. Yes, that's available at the counters of the IRD offices. Is it available on the FAQ on your website? Because I do receive similar inquiries, as you mentioned. So please try to make it as convenient as possible for the public. Another point that we discussed last time is about the form in the annex, and that has to do with the payable AVD under different scenarios. Can you briefly take us through the paper? The last paper is CB bracket 1219/1314 bracket 02. DS, please. In the annex, it sets out the various scenarios providing for the transactions between close relatives. For example, transactions and nomination and addition of names and so on and so forth. So we listed out all the scenarios in a systematic manner in this table, and we want to make it clear through this table of the requirements. The overriding principle is that under the double AVD, we would try to take care of the needs of people who don't own any other residential property in Hong Kong. And at the same time, we know that among close relatives, there may be transactions, and after the sale and purchase agreement has been completed, they may add in names or make nominations of names. So with these considerations, under the AVD regime, if it involves close relatives, and if addition and deletion of name is done in the instrument, they will be exempted from the AVD under the existing AVD regime. But then we have to take care of the fact that if the person's name is added onto the instrument and that person is a beneficial owner of another residential property, he may assume actual benefits in another property. So under this DSD scheme proposed, for the addition of names, he is liable to pay the old AVD rates. So in other words, not the entire instrument will be exempted from the DSD, and the addition of name is subject to the old AVD rates. So we try to go the middle ground and strike the right balance between the old and new regimes. So for the different scenarios that's possible, they have all been listed out in the annex. Mr. Chair? Well, going by your thinking, say if they are joint tenants, so in the interest of protecting their rights, they would just want to add in their name, and because of the estate succession, they will become joint tenants. Then that's all right. But if we want to delete a name from the instrument, what will happen? Now, because of this new regime, they may want to delete their name from an instrument so that they can enjoy exemption in the future. So in that kind of scenario, what will happen? DS, please. The general principle is that if there are joint owners of a residential property or a property, and if a certain owner wants to delete his name from the instrument. And then he would have to be deleting his share from the instrument. And if he doesn't own any other property in Hong Kong, then he is exempted from the AVD. But then, if he does own a property, and if he is going to add or delete his name, and then he's liable to the old the tax based on the old AVD rates. Any other question? If not, Mr. To, in the annex. Well, sorry, it's not the annex. In the BSD, you have to make a declaration. Now, for this Stamp Duty Amendment Bill 2013, have all the scenarios been listed in the annex? And what kind of declaration is needed in these scenarios? Let me cite an example. Say if in paragraph 2 or 1B of the annex, do they have to make statutory declarations that they are close relatives? Well, it's different from providing documentation. Perhaps I'll defer to the IRD colleagues to explain the statutory declarations and furnishing of documents. Thank you, Madam Chair. Under AVD, what needs to be declared is whether he is a Hong Kong PR and is acting on his or her own behalf, or whether he owns another, he is a beneficial owner of another property in Hong Kong. Now, as for transactions among close relatives, then if he applies for exemption, he will have to fill out other forms and then furnish other documentation or documents to prove such relations. Now, in the BSD last time, some people said that now if I am already at a Hong Kong PR, why do I still have to make a declaration on that? But then the emphasis is really on the latter part of that statement, and that is whether he is acting on her own behalf. Now for this DSD now, is statutory declaration required on a close relatives relationship? Now, if that is required, then it doesn't make sense, because that can be proved by way of documents. So are you requiring the statutory declaration only on the fact that he is acting on his behalf? And statutory declaration is not required in other parts of that requirement. If he has already furnished the document, does he still need to make a statutory declaration? Now, under DSD, apart from a declaration that he's acting on his own behalf, he has also have to declare whether he owns any other property in Hong Kong. That should be made part of the declaration. All right, he is acting on his own behalf, and he's not a beneficial owner of any other property. So these are the two things requiring declaration. What about close relationship? No, that's not required. You just have to prove that by way of documents furnished to the authorities. All right. If you don't have any questions on the exemption requirements, let's continue with the other parts.
Now we're on F, in relation to exchange of properties involving residential and non-residential properties, say non-residential for non-residential, residential for residential. Last time when we had a discussion, we talked about an exchange of property if there is a difference in value between the two properties. The difference in value will have to be charged stamp duty. In relation to the consideration paid for equality, the recipient of the property is the Hong Kong PR acting on his own behalf, and that person does not own any other property, the differential will be subject to the old ad valorem rate. In the case of residential property, the relevant exemption will apply. In our last discussion, if it's the case of a person that exchange a residential property for non-residential, non-residential value is higher than the residential one, so there is a differential. In the provision, it caters for the recipient of the property whether that person is eligible for any exemptions. The provision stipulates that if the requirements are met, then the instrument will be charged at the old rate. Last time, the legal advisor pointed out that if a person purchased a non-residential property in the market, compared to a case of exchange, well, for non-residential, there are no exemptions. We do not give exemptions because the person is a Hong Kong PR, that the person does not own any other property. The instrument represents the consideration for the non-residential property. We look at the provisions as a whole and its spirit. We think that there should be some technical adjustments and improvements. We think it is preferable to expressly state in the provision that if the differential for the non-residential property is paid by the recipient of the non-residential property, then scale 1 of the AVD, ad valorem duty, will apply to the differential. Maybe I'm a bit clumsy in expressing it. So for purchase of non-residential, there are no exemptions. It only applies when it's a purchase of residential, but you have to meet certain requirements. When it comes to an exchange, the provisions puts the emphasis on the recipient of the residential property. If the requirements are met, if the non-residential is more pricey than the residential, then the differential is chargeable. Currently, in the provision, is not as clear. The recipient will be charged the old rate even when the exemption requirements are met. And that is not in line with these provisions, that's with the spirit of giving no exemption. So we think we need to make a technical amendment. Mr. To. I'm a bit muddled. Anyway, you agree with what the legal advisor, and you have introduced a technical amendment. Yes. Legal advisor, having heard the detailed explanation, does it address your point? Sorry, it's because of Mike. Okay, in relation to the TPS and communication with the estate agency trade. When it comes to acquisition of public housing units under the TPS tenant purchase scheme, there are some inquiries. Perhaps I would defer to the THB. Mrs. Kwok. It involves BSD and the AVD. When it comes to the DSD, under this regime, our consideration is that the purchaser is acting on his own or not, and whether the person is a Hong Kong PR, and whether he holds any beneficial interest in any other properties. If these requirements are met, then the old AVD rate applies to the consideration. If a person acts on behalf of a minor to purchase the unit as the trustee, whether the trustee is a Hong Kong PR or not, under the current the proposed provisions for minors, for trustees acting for a minor, there are exemptions. If a person purchases the unit, a PRH, on behalf of a minor, the minor is a Hong Kong PR, and the purchase is made by a trustee, the old rate applies. The minor makes a purchase on behalf of a trustee. Well, under the TPS, there are some restrictions, and perhaps I will defer to Mrs. Kwok to supplement. PAS. Thank you. In relation to a TPS, on the 16th of April in Legislative Council, Mr. James Toh asked question for written answer. We have given a reply. When the administration rolled out a number of demand-side management measures, DSD, BSD, SSD, and the current DSD is to respond to the exuberant property market. A lot of members have participated in the 2012 bill scrutiny. We understand that we have to address the need for housing for Hong Kong PRs, and on the other hand, we have to ensure that these demand-side management measures are effective. So we will only provide exemptions under specific circumstances. These include that under the BSD, a Hong Kong PR acts on his own to buy a residential property, and under the DSD, in addition to that, at the time of the purchase of residential property, they should not be the beneficial owner of other properties in Hong Kong, and will only give exemptions of a DSD or BSD under very specific circumstance. When it comes to purchase of residential under the TPS, it will be subject to the restrictions and limitations of the BSD and the DSD. In answer to members' question in the Bills Committee, an acquisition under TPS, if the purchaser is not a Hong Kong PR, but the person has a Hong Kong PR child who is living in that purchase, can that person purchase the unit through the minor to get an exemption of the DSD? Under the TPS policy, sitting tenants of 18 years old or above and relevant tenants in the same unit, they are eligible to purchase the unit. As I said, that the purchaser will have to be 18 years of age and above. So in answer to your question, if the minor child, even if it's a Hong Kong PR, they cannot purchase the unit as a joint tenant. But if the purchasers meet, they are 18 years old, one of them is a Hong Kong PR who does not own another property, then they will be exempted the DSD. That is what is set out in paragraph 10. Well, I'll let Mr. Toh ask a question first. You first. So I need a confirmation. as long as there is at least one Hong Kong PR in the purchase of the unit, even when the other purchases are not Hong Kong PR, they will get an exemption. Is that right? An exemption of the DSD, they only have to pay the old rate. Is that right? They will have to be close relatives, closely related persons with at least one of them as Hong Kong PR. Mr. To, I've read your answer. I'm just thinking aloud. You might have missed out some cases, or maybe a certain case. There is a person. The child is a Hong Kong PR under 18. The mother is not yet a Hong Kong PR. Under the TPS, they are asked if they would like to purchase the unit, and they said yes. And they used the adult, that is the mainland mother, well, the non-Hong Kong PR mother will make the purchase because they have to get mortgage. But if that person is acting as a trustee and the Hong Kong PR son, the Hong Kong PR minor, is the beneficial owner, then the bank will not give you a mortgage. That is where it gets tricky. It's a non-Hong Kong PR, so there is no exemption. But if that person purchases the unit on behalf of the Hong Kong PR minor, then there is exemption, but she can't get a mortgage. So either she pays double or goes without a mortgage. I don't think that is the case for DSD. Yes, Mr. To's understanding is right to a certain extent. When it comes to DSD and BSD, no, let's leave the BSD alone. And I think, we cannot do anything for the BSD in this. So DSD, it's Hong Kong PR with who doesn't own any other properties, then there'll be exemption. But in this case, the mother is not on Hong Kong PR, so she'll have to pay double. But you said no. As long as the mother says that she acts as a trustee on behalf of the Hong Kong PR minor, who is her son, then she doesn't have to pay DSD. Yes, but the bank won't give her a mortgage.
Or, well, she can choose to pay up the full amount up front, but that is not possible, not very likely, because 90% of the price has to be funded by a mortgage. So this is an exceptional case that I can think of. I don't think it works. That won't affect speculation activities at all. They are just sitting tenants there. We're not talking about second-hand HOs as flats or trading in the secondary market. Can you do something to help them? They should be meeting all your requirements in the spirit. Now, under the DSD, a non-HK PR can purchase on behalf of a HKPL minor, and he won't be charged a double AVD. This is something that we have been insisting on. Now, under the TPS, I won't dispute you with the scenario you mentioned, i.e. the problems they may encounter in taking out mortgage. But what I want to point out is that under the TPS arrangement, the requirement is that the purchasers have to be 18 years old or above. So what we should consider is this, that under the TPS, although HKPR minor is a sitting tenant, he can't be a beneficial owner of the PRH. So that's a condition under the TPS. So for our DSD scheme, we are trying to strike a balance, and we have provided for some exemptions. And we don't want the purchases to pay double AVD because they are already paying BSD. Now, there are also some restrictions in terms of mortgage, as mentioned by Mr. To. That's true. Now, for mainland mother, you are allowing them to purchase the flat, and the mother may have an HKPR minor, and she may want to purchase the flat. And you are selling them the flat. Can you think of something to help them, to help such cases so that they won't have to pay DSD? So you should be very clear about the members' views. But you said that a minor can't be a purchaser of under a TPS. Yes, so it will be the mainland mother who will be the purchasing, and she won't be able to enjoy the exemption then. Well, people are not very likely to abuse the TPS because the flats will only be sold to the sitting tenants. So can you do something to help them? Under the DSD scheme, our consideration is very clear. Now, as for the TPS, perhaps we should have to go back and review it together with the relevant departments, and we'll update members on any outcome. Lastly, communication with estate agency trade. Can you also talk about... Oh, sorry, Mr. Pocha, I haven't seen you. On the case mentioned, or the scenario mentioned by Mr. James too, the bank will give you mortgage if you have a guarantor. Well, this is not the case that I'm talking about. Well, the fact is that the minor can't be a purchaser. So I would like to know the DS, the case mentioned by DS, is it just limited to the TPS scheme for non-TPS flats if a parent purchases as a trustee on behalf of the minor and BSD will be levied? But then will the DSD, will there be an exemption for the DSD? Now, if the minor is a HKPR and he doesn't own any beneficial interests in any other property, the instrument will enjoy exemption. In the 2012 BSD bill, the government said that originally there should be exemption, but then for fear of abuse, the exemption has been deleted. And the reason is that even if we count on people making declarations, that will still be abused. So I would like to understand that in this case, you are keeping this exemption. Why aren't you afraid that there will still be abuse? Yes, please make a brief reply. People may, through a trustee buy properties, and how should we verify the identity of the trustee and whether there will be abuse? Actually, in the discussion of the 2012 bill, there we had some thorough discussions, and the administration noted members' concern on this issue, and after due deliberation, we believe that because the BSD targets at managing demands from non-HKPR, the policy intent is very clear. So under that regime, we think that we should tighten up the exemption. and that's in line with the legislative intent, and also can also address members' concern. Now, as for the DSD regime, we still have the same concerns, and the administration understands this. But then we have to consider that the legislative intent of the DSD is to manage individuals who are beneficial owners of other residential properties. So our focus is on this. So if the owner is a non-HKPR minor, then we would also verify whether this person has owns any other residential property in Hong Kong. Well, we still have such concerns. But for such an instrument, a BSD applies already. So that, to a certain extent, is a measure for managing demand side, on the demand side. So we don't intend to tighten up our requirements here, because we know that under our latest proposals, we might harm the interest of HKPR minors, and they may ask their parents to buy properties on their behalf. If we are to tighten up the proposals, these HKPR minors are subject to both the BSD and the DSD, and that is really maybe too much for them. So that's why in the last panel meeting, we have threshed out our ideas very thoroughly, and that's why we don't want to cancel the exemption. So we'll just hit them once and not hit them twice, then. Is that what you're saying? So I'm against this. Now, last time you objected so much about the exemption because of the big loophole, but this time round you're not doing it this way, and it doesn't make sense to me. You have been adhering strictly to your principles, and you are not being logical here. You said you were dealing a blow to them already in the BSD, and not you don't want to deal them a second blow. So would you then be considering the special hard cases with great hardships, and then make special allowances? The government will look at the demand side management measures, and will look at the policy intent, and from that we would be looking how strong the measures should be. And if we are to make specific measures, we would be providing for the least exemptions, and we want to be strict. If exemptions are to be made, they are based on the needs of the actual needs of the individuals. So if you are to take into account the factor of hardship, then there will be too many scenarios for us to deal with. Now, you are a lawyer. We have to lay out all these scenarios. Then it's going to be very hard for us, and we will be facing many constraints too. So that's why we have to lay out, say, certain scenarios, codified scenarios, and then we will allow for exemptions only where they are necessary. And when we drew up the bill, we knew very well that we could not take care of the needs of each and every individual. This is not going to be a watertight policy, and it's not going to be 100% perfect. What we strive to do is to strike the right balance. Now, what about a residential unit together with the parking space to be sold out? Can you codify that too? Because it is a common scenario. Why can't you allow for exemption for the parking space? Because it is so common. And I think it's reasonable that exemption be granted for the parking space. Can you make discretions to give special treatment to the parking space? Well, the administration already said that they are giving some further thoughts to it. Now, on the issue of parking spaces, last time members raised some views, and there have been follow-up questions, and we are giving the issue a serious thought, and we will make a full analysis of the situation. Now, responding to Mr. Chair's question, if we are considering the exemptions, we would have to think about whether the certain cases could be codified, whether the effectiveness of the measures will be undermined, and whether the cases are common. So these are the factors that we will consider. Now, I'm not going to dwell on the issue of residential units so together with the parking space. Now, parking space nature is a non-residential property. So we have to think about the nature of that property. Furthermore, we have to think about transactions involving both residential and non-residential properties. Can we make clear delineation in terms of the law? What kind of factors should we take heed of in terms of the non-residential properties? Now, if we are to be stringent and we have to codify certain scenarios, will it make it difficult for people to comprehend what we are doing? So these are all the factors that we have to consider, and we would be laying out all the factors that we are considering and then update members. We have to tread cautiously. Now, for the moment, we would still be drawing up the provisions based on the AVD scheme that we have now. I am all for a more lenient approach, but then you said last time that you have a good logical thinking, and you are now asking people to make declarations compared to what you are not allowing in the past, and I hope that your logic can be consistent all the way. Mr. To, sorry, speaking not coming through. Well, the officials can make all the decisions themselves. And I thought I was very clear, but then I'm confused. Now, we're talking about DSD. HKPL minor, who is a beneficial owner, and someone acts as his trustee, and then he can be exempted from DSD. But the condition is that this HKPL minor is not a beneficial owner of any other residential property. Now the question is this. Now you have to make a declaration that you don't only own any other residential property. Is the declaration going to be made by the minor or the adult? Well, as far to my understanding, a minor's declaration is not valid at all. Now, if the declaration is made by the adult, but then the beneficial owner is the minor, but then the declaration is made by the adult, and the adult says that this minor doesn't own any other property. Now, what about the case that if the minor does own a property, is the adult going to be penalized because he's making a false declaration? A child cannot, or a minor cannot make declaration. I mean, do you accept that the adult is making declaration on behalf of the minor? Now, as for the declaration arrangements, the RDX, the expert, but what I can say is that in verifying whether a person owns any other residential property, then the IRD colleagues can explain further. Now, the verification is based on records in the land registry. Now, as for the declaration, perhaps the IRD colleagues can supplement. IRD, please. Thank you.
I think for Mr. To's point, if it's a minor who is to make the declaration, We will further look into it. Hopefully, when it comes into operation, it will be watertight. If the trustee is making a declaration on the minor's behalf, but there are matters that the trustee may not know. But according to the declaration, it says that it's true to his understanding and belief. I think what we need to clarify is that you require the adult to make a declaration, and as far as to the best of his knowledge, the child does not own any other property. Just go back and think about it. Yes, we will do that. Mr. Ibrahim Sheikh. I want to hear some explanation from the administration about TPS. Those under 18 years old. It's not like the 2012 bill. So how come there is 18 years old here? Is 17 years old? Is under the TPS. The granddad would like to buy the property for the grandchild, and it can't be done then. Mr. Toh, the granny may be allowed to stay in the unit to take care of the child, and he may be an authorized tenant. I think close relatives do not include grandparents. I think his point is that the purchase is funded by the granddad for the 17-year-old to buy it, but under the TPS he can't purchase it. But if, what about the granddad buying it? The granddad is an authorized tenant, but the granddad is not a close relative, so it's not allowed. And I think that what members are trying to say is that they want a blanket exemption. I wonder why you put 18 years old here. Seems that is not logical. Is it because these people have no money? That's why you have to put in a restriction of 18. You don't have to do it this way. They live in a public housing estate. You allow under 18 to make a purchase in the private market, but not under the TPS. Well, I think it will be the most simple to give an exemption. We need to go back to look into those cases. And this involves the design of the TPS, but I understand the points of Mr. Sheikh and Mr. Toh. Mr. Sheikh. You were talking about a parking space. Let's look at the lease condition. The lease condition may be residential with parking spaces. Parking space is non-residential, but the lease condition is about the entire development, and they are residential. So there are no other non-residential. It's residential. That's the land use, but they are the developer is required to provide parking spaces under the town planning ordinance. There are two types of car parks. One that can be rented to outsiders, and the other for occupants of the estate only. That is, flat owners have an exclusive use of these parking space. I asked for some time to deal with it. We don't have much time, but we'll do it as soon as possible. For non-residential properties, we have to emphasize that we need to introduce demand-side management. Parking space is non-residential in nature. That is something we have to accept. In the last discussion, we've been working with the planning department, lands department, There are many different scenarios. It may involve the land lease. The land lease may evolve, and there may be changes with the number of parking space, whether it is combined with the sale of the residential properties and allocation of the parking space. We will consider it when the clear requirements are met. What we need to consider is that we need to have demand-side management measures on parking space. When it comes to exemption, can it be clearly stated? There may be different land conditions in the same development. We need to be very careful. I think we should stop at the discussions of parking space. We had a discussion last time. I asked the question because it may have something to do with the land lease, and so it will have to be dealt with very carefully. Go back to ask your colleagues. Are you, Mr. Toh, you're going to make a comment? I heard the DS say that she is aware about the complexity of the matter. I too. For certain situations, there should be some exemptions. Say, for example, if it's a purchase of several parking spaces to generate rental income, of course, there should not be any exemptions. For residential land use, sometimes someone may buy a number of parking spaces, and someone may buy one residential unit with 100 parking spaces, and I don't think they should get exemptions. But for a normal member of public, the purchase of one residential unit with one parking space should deserve an exemption because it's normal. It's a reasonable arrangement. I think members have made themselves very clear. Mr. Tse, I'd like to declare interest. On this issue, I think, well, perhaps there might have been this might have been answered before. Under the common law, when it comes to beneficial interest, there may be constructive ownership, reversed ownership, or when the consideration is paid. Sometimes you don't even know which is which. If a property is held by a limited company and that person does not own any property in his own name, then you treat that person as not having any property, even if the major duty of the limited company is to hold properties, and all the shares belong to this single person. Well, that's often the case for BVI companies. So even if the person owns a number of properties through a limited company or an overseas company, and if no property is owned by this individual in name, then you treat him as not having a beneficial interest in any property, right? I will have to be very, very careful because I think there is a specific case in the mind of Mr. Tse. A person is a different legal entity from a company. We stick to that. That is the concept applied under the BSD and the DSD. If an individual does not own any beneficial interest in any property in his own name, and if he is a board of director or shareholder of a company, regardless of the nature of business of the company, and the company owns companies, the beneficial owner of these properties is the company. So despite the fact that that individual owns these companies, we don't treat these properties owned by the company as those belonging to the individual. So the instrument of a purchase of a property bought in the individual's name will be charged by the old rate. It sounds proper and in order, but I'm afraid that perhaps in the future you may ask people to make declarations of interest in any company. So when it comes to beneficial ownership, you talk about the person who makes decisions, have control, or is funding the transaction. So you have to state your policy stance in the interpretation very clearly, that you will only focus on one layer. If the property is owned through a company, then it will not be considered. I don't want to brag, but as I said, that we treat an individual as a separate legal entity as a company. We stick very strictly to that. And as to whether we need other interpretation or guidelines, we will look into that. When there are adjustments of tax or new types of tax introduced, the IRD will, if necessary, promulgate guidelines and set down interpretations. And as I said, we stick to that principle, as we did under the BSD. All these discussions is part of the scrutiny, but for some people, this protection is not safe enough. I may have other questions to ask in relation to the IRD guidelines, whether they are of the same stance as yours. Please go back to think about it, whether you need to clarify this in the interpretation. Beneficial ownership is one that is owned by an individual's name, and beneficial ownership through a company will not be considered. Mr. Toh. I think it's just to let the administration know, now that there is a requirement of declaration. There are two ways. Well, you have to declare that you are not a beneficial owner of any other property. You have to consider the wordings very carefully. Another point is you need to consider whether you have to add something like beneficial owner of any other property in the same name, in this name. You have to put in some qualifications to pin it down to an individual. I do agree that if you only talk about beneficial ownership, it's risky. It's just an example. Maybe in the resumption of second reading, you may make a reply.
I think that will provide a safeguard. As I said, in common law, we talk about beneficial ownership. There may be a lot of problems. Say, for electrical members, we declare interest. I don't know whether you are doing it, but even if I am holding some properties through a company, then I will also declare it, because I do have a beneficial interest in that. So by the same token, I hope that the government can stick to the principle, i.e. that only the individual as a beneficial owner will count. And I think the interpretation now, as it stands, is not good enough. And I'm just worried that there may be loopholes. Yes, I've heard your views. Thank you. Madam Chair, I don't know whether I should ask this question now, because I know that I may not be given the opportunity to ask this question in the future. Transactions of non-residential properties among close relatives, why is it that we don't have an exemption on that? Now, if a father owns a store and he is transferring it to his son, so this is passing on his business to his son, perhaps he will not wait till he passes away to transfer it to his son. Now, if he does it when he's still alive, because this is a non-residential property, then it's liable to DSD. Then that's not reasonable. DS? Well, please be brief in your response. On the letter submitted by Mr. James Toh on the 16th of April, there is this letter containing 22 questions, and that's in one of them. I haven't answered that submission yet, but we will give answers to your questions at one go. As Mr. Toh said, you may not be happy with our answer, but for non-residential properties, we don't plan to give exemptions for non-residential property transactions among close relatives. Our thinking is that the exemption will be granted to people who need their properties for their own use. So that's why the exemption is granted only for residential properties and not non-residential properties. We don't want to undermine the effectiveness of our policy. I think in the last meeting, we did reply to that. So in our response to Mr. Toh's letter dated the 26th of April, we'll try to give you more details. All along, we don't plan to widen the scope of exemption to cover transactions of non-residential properties among close relatives. You are doing all this because you want to curb speculation, but if we're talking a father passing on his non-residential property to his son, then where's the speculation? So that has nothing to do with speculation. Say, I can't build a close relationship, say, with Miss Dory Lee, so that's not possible. So you please appreciate that you are doing all this to curb speculation, and so you shouldn't just focus on the self-use needs of residential properties. You have to take all these other factors into account as well. Yes, sorry, speaker not coming through. Speaker not coming through. Sorry, speaker not coming through. Sorry, the speaker is not coming through. Sorry, the speaker is not coming through. I talked with peers who focused on conveyance on sale, and many of them understand it to be the fact that exemption is granted to conveyance on sale covering one property only. The government has sent a letter to the Law Society on the 22nd of February 2013, and perhaps I'll ask them to copy this letter to you. In this letter, it says that clearly, it says acquisition of a residential property. It is a single verb is used here. If it is more than one property, it will not be entitled to exemption. So that's the common understanding within the trade, and that is one instrument can cover only one residential property. So if multiple properties are covered by one instrument, then that exemption doesn't apply. Now, is this in line with the government policy? If it is misleading, what kind of remedial measures will you take? So, DS, would you be taking a look at the paper first before responding? Now, please allow me to respond here. And DS said at the outset that she would make a consolidated reply later on. Well, I must clarify now. We've been keeping a close dialogue with the Law Society, and we've exchanged several correspondences with them, and we've also passed them to this panel for your record. Mr. Paul, that's in paragraph C, Roman letter 1, under exemptions and exceptions. So I must stress first that in our several letter exchanges with the Law Society, and actually we went down to the Law Society to explain the provisions. When one instrument covers multiple properties, we did make some explanations on how the instrument should be stamped. So our stance is that, as I said, or as the document submitted to the panel last time, the DSD is drawn up based on the AVD regime. Now, if the duties are to be imposed, we would calculate the rates based on the conveyance on sale or the agreement for sale and purchase. It's an instrument-based system, so the stamp duty will be levied based on the total consideration. Myself and my colleagues have actually explained that very clearly to the Law Society, and we have also submitted documents laying out all these. So the documents have also been submitted to this panel for your records. So if there is room for further clarification, then I would do so. Now, last time, a member also said that if this is the approach, i.e., this is an instrument-based regime, well, people use one instrument to cover multiple properties, and then they can avoid a DSD in doing so. Now, on this concern, we will go back and take a look. But anyway, as we explained last time, the DSD is based on the existing ABD regime. And if we are to introduce a change to this, then we have to take a broader picture, and we will have to think about whether there are cases where people are buying two linked flats, and what about the situation involving developments in the NT. We have to tread carefully because it's going to impact on the society comprehensively. Well, I welcome the DS to make clarifications on that. Some lawyers acting on behalf of developers on new residential complexes, they have this misunderstanding that only one property in one instrument is exempted. If multiple properties are covered in one instrument, then DSD will apply. So as you said that you have communicated with the Law Society. I'm not sure whether your point has been made clear. So can you ratify your guidelines to the Law Society? Because many lawyers are misunderstanding the situation. Mr. To. Well, my understanding all along is that exemption will only apply when one property is covered by one instrument. But then an estate agent told me just now that even if you are covering 50 properties in one instrument, all will be exempted. So he said that he learned it from a seminar earlier. So those maybe who have attended the seminar will get the correct understanding. Well, Madam Chair, I have another question or an issue for the administration to consider. If you are going to buy a property and you want to apply for exemption, you have to make a declaration. You are acting on your own behalf. You are a PR, HKPR, and you are not the beneficial owner of another property. I don't know how would you phrase the fact that you are not the beneficial owner of another property. Now, if I use one instrument to buy, say, 50 flats in Taikushing, that would say that happened a long time ago, and back then there was no all these stamp duties, special stamp duties, and so on. Now, what do you mean by not property owner of another property? How do you describe this accurately? What impact will you bring if the phrase is not constructed accurately? Well, I was laughing or joking with Mr. Abraham Shek. Now, if one instrument covers 50 flats in Taikushing, as far as we understand, it can enjoy exemption as long as you don't own any other property. Now, if I cover one instrument, I cover 50 residential units and one store in one instrument, would you be calculating the AVD based on the fact that or the rate for non-residential property? It seems that you can't do all sorts of this sort of combination here. Last time, we discussed about the coverage of the instrument. Perhaps we should focus on some other topics in this meeting today. But then I still want to reiterate that if one instrument covers multiple properties, and if on the date of the acquisition, the purchaser makes a declaration that he doesn't own any other property, and we found them to be so in the land registry, then the old rates will apply. Now, in the law societies, so in our letter to the Law Society, we also enclosed that letter together with our paper submitted to the electrical on the 18th of October, paper 1314/01. We actually held seminars with the Law Society, and in those seminars we made clear explanations, and it touches not only on the policies but also the systems and also the overriding principles. Under the present DSD proposal, and what rate will apply will depend on the instrument. If we are considering the exemptions, whether they are replacement properties or other properties, the provisions clearly state that they should be properties. So there are different considerations for two different systems. So if an instrument covers both residential properties and non-residential properties under the AVD regime, we're talking about two different types of properties. We have to look at the nature of the properties and to calculate the tax rates, i.e. whether they are residential or non-residential properties. And the applicable rates will also depend on the total consideration of the instrument. That has been an established practice under the AVD regime. I think we've been discussing this topic for quite a while. Perhaps we would leave it up to the administration to give it a consolidated reply. Well, perhaps we will now look at LC paper CB 1219/1314/03, and that was a response made to the submission made by Mr. To on the 24th of February. Then touches about exemption for mentally incapacitated persons, charitable bodies, changing properties, and so on. DS, please take us through the paper. If time allows, perhaps I would be detailed. Mr. Toad submitted a letter towards the end of February. We spent some time in drawing up answers to his questions. At that time, the 2012 bill on BSSD was endorsed already. And Mr. To, in view of that bill, was trying to ask his questions related to this other bill. The first issue is paragraph 2A. And that has to do with the negative vetting mechanism. And that has to do with Clause 22, Section 63D. In the last meeting at the clause by clause, and we're almost about to discuss that clause.
去到嗰一點嘅。
Members may recall that under this bill, it is stipulated the FS may by Gazette amend the percentage and monetary amount of scales 1 and 2 in the schedule. The DSD covers the tax span of the value of the property and the applicable tax rate. We think that this measure is to address the exuberant property market. It is an exceptional measure. This measure should also cater for changes in the property market, and it should also enable swift responses. Mr. To also asked that during the scrutiny of the BSD bill, members expressed concern the appropriateness of doing it by subsidiary legislation in this way. Members have also proposed different adjustment mechanisms. Some members expressed concerns that the adjustments may be upwards or downwards. The administration would like to, with certainty, swiftly introduce adjustments. If the adjustment is confined to downward by way of negative vetting, and in an upward adjustment, it will be by a bill or positive vetting. For ease of discussion, we call it a hybrid approach. Under the 2012 bill, in a scrutiny and in a subsequent passing, there are many different discussions. Under this bill, and I'd like to say to members that BSD is 15%, a flat rate. The DSD is based on the AVD, so there are tax bands and tax rates. It's not a single tax rate. Proposed adjustments may touch on the tax band and or the tax rates, the amount, and or the rates, the percentage. Can we, in a simple way, specify downward or upward adjustments and adjust the monetary amount under the tax band to reflect the hybrid mode? We think that this will be different. The system itself is different from that under BSD. In the schedule, there are two scales. Scale 1 is the DSD. Scale 2, the original rate. The provisions will specify the application of which scale. we think that if we need to introduce a hybrid mode in the adjustment mechanism, it will be difficult, and it does not give a clear indication with certainty when to use which. Now, back to the negative vetting. We would like to, as soon as possible, with clarity through Gazette, announce the tax band and the tax rates for the information of parties involved. If we use positive vetting or by way of a bill like what we're doing now, this is going to happen. The tax bands and the tax rates will be announced under the bill. Parties to a transaction and the IRD will have to pay a tax band and tax rate subject to the result of the scrutiny. So they don't know what to pay. There will be uncertainty in the market. The rates or tax or duty collected may not reflect the genuine amount. We want to give clear, certain message to the market. Negative vetting will be the ideal approach. Let me pause here. Mr. James Toll. I won't be long-winded and repeat what I've said last time, but I will still have to repeat myself for the record. Ideally, we should do it by way of legislative amendments. You may recall towards the end of the 2012 bill, the Secretary, Mr. Anthony Cheung, undertook that it would be done in two ways. Of course, I won't seize the chance to ask how the THB is doing using this bill, because I think they're already in trouble with the report of the marine disaster. If the administration finds it acceptable to introduce amendments through legislative amendments, and now they insist on negative vetting, I think they're contradicting themselves. Take it to the highest. Mr. Martin Liu's amendment for the 2012 bill. It will be effective first, then there'll be a Gazette, and then within a certain time, say 6 months or a year, the amendment will be confirmed upon agreement and support of maybe 2/3 of legislators. Well, now you talk about a swift response. And I and some other members think that you should let at least half of the legislators support before it will be endorsed. If you get half of either FC or GC, you will be able to get it endorsed, even though as a whole over 50 members opposed to it. I don't think this will be a reasonable and fair approach. Now, according to paragraph 4, you said that it involves adjustments to the tax bands and the tax rates. If it's so complicated, then why can't you use the legislative amendment requiring at least the support of half members? In the past, adjustments to the stamp duty is by legislative amendment. you may say that it's only on a temporary basis, but there is no sunset clause. So it may be permanent. We don't know because don't tell us when it will expire. So this is exceptional and temporary. And you said they should be negative vetting and not by way of a bill, by way of a legislative amendment. If you insist, I will propose amendments. I may also give you several options, depending on whether Mr. Martin Liu will make a similar amendment. If he doesn't, I will mirror his amendment and introduce one. If you insist on this, I will veto your bill. Let me make myself clear now for the record. Mr. Porter. The administration has emphasized on a number of occasions that they don't want to affect or undermine the ad valorem tax or stamp duty system. But if it is negative vetting, you're actually introducing a new mechanism with no sunset clause, as Mr. To puts it. Even if the FS thinks in the future that the situation has improved, the SSD or the BSD will be reduced to zero. The framework can still exist. And when the occasion calls for it, they will be able to revive it without going through the LegCo. Of course, the administration would like to have more power and more flexibility. But we're talking about a well-established and well-practiced stamp duty system. Flexibility aside, this policy of the administration has seriously changed the stamp duty regime that has been in place for so many years. I would like to answer all these questions. Negative vetting mechanism for adjustment. We want to cater for the ever-changing situation in the property market. The demand-side management measures is to introduce adjustments to the property market in response to the exuberance. And as to whether it has changed the regime and whether we will have more power than we should have by negative vetting. I'd like to say that the subsidiary legislation by negative vetting is still scrutinized by the LegCo. What is different is that when a resolution is announced and a gazetto made, from the time when the resolution is announced to the scrutiny, it gives certainty and clarity to the market.
Conversely, if we do it by way of a legislative amendment, i.e. the existing practice, or Mr. To mentioned that Mr. Martin Liu has made a suggestion in relation to the 2012 bill, whether it is applicable here. We still need a resolution to be scrutinized. And in terms of collecting the rates and the value bands, and there will be uncertainties in the market. And people or players in the market may make decisions based on certain unclear factors. So that's the distinction between the two systems. Even with the negative vetting mechanism, that is also practiced in another legislation, and the Electoral can still establish a Bills Committee to scrutinize the subsidiary legislation. A follow-up question. The DS may sound very reasonable, but if we look at the 2012 and 2013 bills, the government didn't have this negative vetting framework first, and then the government said that there will be a retrospective period. Now, there were no major chaos which happened, and say for the baby formula restriction order, the import-export ordinance is not the appropriate framework for catering to that issue or matter. So because of filibustering, we didn't have the chance to scrutinize that other ordinance, and there wasn't nothing much we could do about it. Now, if filibustering is going to happen again in the future, we might also miss out on the chance of scrutinizing the bill properly. Now, third, if the logic of negative vetting mechanism stands, then it can be applicable to a lot of other scenarios. So, going by your logic, why do we have to give you so much discretionary power to deal with it the way you proposed? The proposals in our proposed bill have retrospective effect. The proposed value bands, however, will only apply after the scrutiny of the bill is completed. Say, during the scrutiny of the bill, any proposals raised would be included in the ordinance to be enacted. And the tax rates laid out in the enacted ordinance will have a retrospective effect. Now, on the market today, people are now taking into account the proposed rates in making purchase decisions. There is no major chaos, right? Yes. For any proposals raised during the scrutiny period will be included in the ultimate ordinance, and they will have retrospective effect. Well, the negative vetting mechanism is better than the legislative amendment approach in terms of giving more certainties to the market. And the retrospective effect area covers only the tax rates and not other areas. And some in the past, the tax rates and are covered or are covered in a schedule in the bill. So this is the adjustment mechanism that we are proposing. Let me suggest this. Well, not many members are here at the meeting. This is going to be a very contentious issue, and earlier members have asked that the secretary come to the panel to explain to us. The secretary is positive towards our request, and I think we would set up that. And perhaps you should communicate with the various political parties and make further reviews. And actually, the points covered have were thoroughly discussed in the discussion on the 2012 bill. Now, not many members have spoken today, and they may not necessarily represent the views of the LegCo as a whole. I treasure the opportunity today to hear members' views. On negative vetting mechanism, the focus or the emphasis is really on the fact that because the bill covers the value bands, and if we adopt a hybrid mode, then that would not be implemented like what we did with the BSD scheme. So I just want to bring this out to the panel. I think this is very clear, but I think you have to go back and think about Mr. Martin Muir's proposal raised with regard to the 2012 bill. I think it was the proposal is in the middle ground and responds to various demands. Well, in terms of doing it by way of legislative amendments, of course, there will be more uncertainties. But could those uncertainties be accepted? We have to think about it. Or, well, all these points have been covered in the discussions on the 2012 bill. All right, we have a few members left. Shall we stop here? And we don't want to go into new topics because I still want to take part in the meeting next door. The next meeting will be held on the 13th of May. I think a circular has been sent out already. The 13th of May, that's for the next meeting. We will continue to discuss paragraphs or points 2, 3, and 4 of this letter. We will also go by clause next meeting. As to the date of the next meeting, earlier on we talked with the Secretariat. We hoped that a meeting could be held in early May. We have already marked down some dates as well. Can we be allowed to discuss further with the Secretariat to, say, advance the meeting or hold meetings more frequently? Well, Madam Chair, when's the next meeting again? Sorry. 13th of May for the time being. But the DS wanted to hold a meeting earlier. So I would like to attend all the meetings. I have a number of hearings related to the PAC, and actually several of us are in that other committee as well. 3 of us in that committee are public hearings. Yes. 3 members are members of the PAC. I'll try to attend as many meetings as possible. Thank you.